Level 1. The New Robe. You're appointed to the bench at 44, 15 years as a prosecutor, 3 as a federal clerk, a reputation for being thorough, fair, difficult to read. The governor shakes your hand. Your family watches from the gallery. You raise your right hand and mean every word of the oath. You actually mean it. That detail will matter later. Your courtroom is in a mid-sized city with a mid-sized crime rate and a mid-sized budget that's been cut 3 years in a row. Your clerk is 58 and has worked for 4 judges before you. She knows where everything is and tells you almost nothing. The bailiff nods at you on day 1 and says the last judge liked things quiet. You ask what that means. He says you'll figure it out. The first month is procedural, arraignments, bail hearings, motions you've seen 100 times from the other side of the bench. You rule by the book because that's what the book is for. Defense attorneys seem surprised when their motions get fair readings. Prosecutors seem annoyed when you ask them to actually justify their evidence requests. You assume this is just the adjustment period. New judge, new rhythm. Everyone will calibrate. They don't calibrate. The annoyance stays. Level 2, the pattern. 3 months in, you start noticing things that don't add up. Small things at first. A prosecutor named Holt keeps filing charges that are slightly overweight for the evidence. Felony when the facts say misdemeanor. Maximum sentencing recommendations on cases where the defendant has no priors and the victim isn't pushing for it. You reduce the charges twice. He looks at you from the floor like you've personally insulted him, like this isn't how it's supposed to go. Then there's the defense side. Attorney named Carrasco shows up on a trafficking case. Mid-level defendant. Solid evidence against him. Carrasco files a motion to suppress that's technically competent, but strategically odd. He's not trying to win it. You can tell. He's going through motions at half speed, making arguments he knows you'll reject, not making arguments that might actually work. You rule against him, and he nods like a man who expected nothing different and wanted nothing more. You pull the case file that night. The defendant was arrested with $40,000 in cash and 8 kilos. The arrest report is clean, almost too clean. The language is templated, the same phrasing you've seen in 4 other reports from the same narcotics unit this month. You pull those files. The phrasing is identical down to the paragraph breaks. Either one officer wrote all 4 reports or someone is copying a script. You flag it. Send a note to the DA's office asking about the arresting officer. Nobody responds. Level 3, the envelope. You don't get an envelope. That's not how it works at your level, in your city, in this particular arrangement that you're only beginning to understand. What you get instead is a dinner invitation, the kind that looks social and isn't. A senior partner at a firm that does a lot of criminal defense, a city councilman you've met twice, and a prosecutor who golfs with the DA every Sunday. Nice restaurant, private room, good wine you don't drink because you drove yourself. The conversation is careful. Nobody says anything illegal. Nobody needs to. They talk about the city, about case volume, about how backlogged the system is, about how cooperation between all parties makes things run smoother for everyone. The senior partner mentions a real estate developer who has a matter coming before your court next month. Just mentions it, the way you'd mention weather. The councilman says the developer is a good man, community-minded, employs a lot of people. The prosecutor says he hopes the matter resolves efficiently. They all look at you. You say the court looks forward to hearing the case on its merits. There's a pause that lasts about 2 seconds too long. Then the conversation moves on. You drive home and sit in your car in the driveway for 20 minutes. You've just been told, in the politest possible language, that this city has a system and you are expected to be part of it. You knew corruption existed. You prosecuted some of it, but you assumed it was episodic. Individuals, not architecture. What you felt in that room wasn't individual. It was institutional. It was load-bearing. Level 4. The cost. The developer's case comes up. Securities fraud, relatively minor, first offense, technical violations, the kind of case that usually settles with a fine and no jail time. Except the evidence is actually solid. His company defrauded 34 small investors, retirees mostly, out of a combined $2.1 million. They lost savings they can't replace. You read every deposition. You look at the numbers. This man knew exactly what he was doing. The prosecution recommends a fine and probation. Holt is on the case, and he barely argues for more. The defense barely argues at all. Both sides want a quick, quiet resolution. The courtroom is nearly empty. No press, no victims present. You're supposed to rubber stamp it and move on. You sentence the developer to 26 months in federal prison. The room goes still. Holt looks like you've detonated something. The defense attorney closes his notepad slowly, carefully, like he's trying not to make any sudden movements. You explain your reasoning from the bench, the deliberate nature of the fraud, the vulnerability of the victims, the absence of remorse in any filing. The sentence is within guidelines. It's defensible. It's correct. You go home and sleep fine. What happens next doesn't happen immediately. It happens slowly, the way pressure builds. Your clerk starts processing your paperwork slower. Motions you need for tomorrow appear on your desk the morning of. The bailiff stops making small talk. Cases you should be getting assigned are going to other courtrooms. A judicial review committee schedules a routine audit of your dockets. Routine. They use that word specifically. You've been on the bench 9 months and you're getting audited. Your phone rings one night. Unknown number. You answer because you always answer. The voice is calm, not threatening, almost disappointed. It tells you that you're new and perhaps don't understand how things work yet. That the developer situation created problems for a lot of people who had nothing to do with his case. That there are ways to serve justice that don't require disrupting the entire ecosystem. You ask who's calling. The line goes dead. You report the call to the State Judicial Conduct Board the next morning. They open a file. You never hear about it again. Level 5. The fight. You start keeping records. Every anomaly. Every templated arrest report. Every case where the charge doesn't match the evidence. Every plea deal that looks less like justice and more like a transaction. You build a spreadsheet that takes you 3 months of late nights. What emerges is a map. Certain defense attorneys rotate through certain prosecutors on certain case types. The outcomes follow a pattern that has nothing to do with evidence and everything to do with relationships. Money moves. Not always, obviously. Sometimes it's referrals. Sometimes it's future considerations. Sometimes it's just information. A tip about a case. A heads up about a search warrant. The narcotics unit is the worst. 6 officers whose arrest reports you've now compared across 40 cases. Same language. Same structure. Evidence that appears with suspicious convenience. You can't prove the searches were fabricated, but you can see the seams. You start granting suppression motions that other judges on this bench have been denying for years. The prosecutors appeal. You write opinions that are 40 pages long and airtight. The appellate court upholds you twice. The third time they reverse you on a technicality that has nothing to do with the substance of your ruling. Carrasco, the defense attorney who threw his own client's case, approaches you outside the courthouse one afternoon. He doesn't stop walking, barely looks at you, says 3 words quietly as he passes. They're watching you. That's all. Then he's gone, and you're standing on the courthouse steps wondering if he just warned you or threatened you. You contact the FBI, not the local field office, the one that shares a building with the prosecutors you're investigating. You go directly to the public corruption unit in the next state. You bring your spreadsheet. You bring the templated reports. You bring the timeline of what happened after the developer's sentencing. The agent across the table doesn't look surprised. She looks like someone who has been waiting for a particular piece to appear, and it just did. She asks how long you've been on the bench. You say 14 months. She says you've documented more in 14 months than they've been able to build in 4 years. She asks if you understand what comes next. You say yes. You don't fully mean it. What comes next is 18 months of living inside a case you can't talk about. You go to work every day and act like nothing is happening. You rule fairly. You keep building the record. You wear a wire twice, which is surreal in a way no law school class prepares you for, sitting in your own courtroom in your own robe with a recording device under your shirt, while a prosecutor suggests that a particular ruling would be appreciated by people you both know. You keep your voice neutral. You ask clarifying questions. You give them enough rope. The agent said that was the phrase they use, rope. The arrests happen on a Tuesday morning. 7 people. 2 prosecutors, including Holt, 3 officers from the narcotics unit, the senior partner from the dinner you didn't drink at, a clerk from the DA's office who was the connective tissue for most of it. The courthouse goes silent in a way that has weight. People stand in hallways not talking. Your clerk, who has worked here for 22 years, sits at her desk and stares at her hands. You go into your chambers and close the door. The robe hangs on the hook where it always does. Your family's picture is on the desk. Outside, through the window, you can see the steps where Carrasco warned you without warning you, where defendants come in scared and sometimes leave scarred. The system in this building was rotten for longer than you've been alive. You didn't fix it. You handed the FBI enough to crack it open. Those are different things. Fixing takes years, oversight, money the city doesn't have, cultural change that nobody can legislate. What you did was hold the line for 14 months in a building designed to wear you down. You made decisions that cost you professionally, that isolated you, that put you in a position where an unknown voice called your home phone to suggest you reconsider your career choices. You made them anyway, not because you're exceptional, because you're a judge, and in the absence of extraordinary circumstances, that word is supposed to mean something, and in the presence of extraordinary circumstances, it's supposed to mean more. The case will take 2 years to prosecute. Some charges will stick, some won't. The system will reform partially and then drift back toward comfortable patterns because systems do that without constant pressure. You'll stay on the bench, not because it's comfortable, it isn't, but because the alternative is leaving the chair to someone who will use it differently. You put the robe back on. There's a bail hearing in 20 minutes. Someone's waiting to find out if they go home tonight or back to a cell. That's the job. That was always the job. Everything else was just noise you had to survive long enough to do it.